I am Apostle Nona Ray.
And I'm Apostle Glenda Ray.
And we are God's Girls, keeping it real. Well, good evening, God's Girls viewers. Thank you all so much for joining in with us tonight. We're pleased to be here. I'm Apostle Nona Ray.
And I'm Apostle Glenda Ray.
And we are God's Girls, keeping it real.
We're here on another
Thursday night with just another great show waiting for you guys. So please go ahead and share. Let people know we're on the air. We have some wonderful people we want to introduce you to tonight.
Oh, this month has just been so powerful.
It's been great.
So we're coming up on the end. This is the last Thursday in the month that we'll be doing this segment of God's Girls with the political aspect and the candidates that's been coming on. And the other part of that is that Meta is saying that they are going to shut down all of the ads come November 1.
November 1st. And so we've been working diligently to try to introduce you all to and give a platform to those candidates that we've been able to round up, to bring them to you all, and to let you guys just, again, give you some information so that when you go to the polls, notice I said when you go to the polls, because you got to go to the polls.
Or if you haven't
been already, you can go now. You don't have to wait. But if you do wait, when you go to the polls, you'll have information about the candidates, those that are running, and where they are. It is just important that you guys know what you're picking and why. So we've dedicated this whole month, Apostle, to just talking to candidates and doing all of that.
We felt like it was very significant because a lot of times people are not informed. And I know even for myself, there's been times where I've gone to the polls and I'm like, who are these people?
Sure.
I don't know who to vote for. I don't know what they stand for. And so that's what we've endeavored to do, is to bring the candidates so that they can share their platform. You can get a touch of their personal side to know who they are, why they're running. And so, again, share the broadcast. Let others know that those girls are on the air again. And we are going to make introductions. As you said, we've got some wonderful guests with us here today.
Very special guests.
We have Justice Liam Brennan, who is running for the appellate court in District 2. Is that correct? District 3. And we also have Justice Michael Burke, who's running for Supreme Court Justice, District 3 as well. Welcome to the show, you all.
Thank you
so much
We're
for coming.
very happy to have you all here. And so we're sitting with, great judges and very powerful men that are seeking for some high seats, Supreme Court, appellate court. And so again, in this broadcast, we want to introduce you to them, but we also hope that it is helping you to understand this entire judicial system. We've had another judge on, we've had some other people on, so hopefully it's helping you to understand how our judicial system works. So if you have questions, please make sure you put them in the chat. They'll get them to us and we'll ask those questions for you.
And so I'll just kick it over to you, Justice Burke. We had some conversation prior to the start of the show in terms of what is the proper titling. And so sometimes we hear Judge Burke or Judge Brennan, but at that level of where you're running, speak to us about the difference in the names and judge and justice
titles.
Sure, there are 3 levels of court. The trial court, I think Judge Hart may have gone over that with you, the trial court, the appellate court, and then the Supreme Court. The judges on the trial court are referred to as judge. But in Illinois, on the appellate court and the Supreme Court, we're referred to as justice.
Okay,
Justice.
great,
Okay.
great.
So we will call you
Well,
Justice.
Yes.
you can call me Mike.
What an honor. Okay.
And so, Justice Brennan, you're running for Appellate Court District 3, but you're already sitting on the Appellate Court. Talk to us a little bit about that.
So some of your listeners may remember the Justice Kilbride was the 3rd District Supreme Court Justice, and he did not survive his retention bid, which opened up a spot on the 3rd District Appellate
Supreme Court,
which was the first spot since, I think, 2000.
Wow.
So it had been a long time, and that was a surprise to a lot of people because retention, that's the yes or no, should this judge be retained.
Oh, okay.
Almost always that works, but it did
Okay.
not work for Justice Kilbride. So that opened up the 3rd District Supreme Court seat, which caused the legislature, which is majority Democrat at this time, to take a look, I believe, at the boundaries and their likelihood of success.
Okay.
And they, based on their analysis, for the first time since the 1960s, they redistricted the Supreme Court boundaries, which are the same as the appellate court boundaries.
Oh, wow.
When
Okay.
they redistricted that, at that point in time, Justice Burke, not to speak for him, was running for the 2nd District Supreme Court, and I had been placed in Justice Burke's appellate seat, and I was running for the 2nd District Appellate Court.
I see.
The redistricting took where we both live, DuPage County, and moved it out of the 2nd District and put it into the 3rd District,
Oh,
which meant for me, there was no seat I could run for anymore. So I closed down my campaign. Justice Burke was able to instead run for Justice Kilbride's spot, which is what he's still running for.
Okay.
So that's kind
Okay.
of the evolution of why we were sitting in 2nd District seats,
Okay.
but running for 3rd.
Okay.
And then after that, an appellate seat, judge retired from the appellate, justice retired from the appellate court, 3rd District. So a seat opened up. So Justice Brennan jumped back into the race
Okay.
for the new 3rd District.
So it was a matter of who's on 2nd and
Right,
who's
I
on
know.
3rd.
In this
Uh-huh.
case, that's
It's very
exactly
complicated.
right.
Wow.
Okay.
Okay.
And so 3rd District, can you tell us the area that 3rd District covers?
Sure, it's DuPage, Will, Kankakee, Iroquois, Grundy, LaSalle, and Bureau counties. So it's 7 counties.
We were just saying, I've never heard of Bureau County. So
have
we-
not
County-
either.
Princeton.
County seat is Princeton.
Okay. I had never heard of Bureau County, so I learned something as we were kind of looking at some things about you guys. Yeah, we did. We looked you up. We looked you up.
Only half of it's true.
Yeah. I can imagine that's true.
So in those counties, then that means that when there is a court situation that comes to those districts in all of those counties, then you would hear those cases.
The appellate court would hear the cases from the trial courts in those counties.
Okay.
Because everyone gets an automatic appeal to the appellate court. If
Okay.
you're in the trial court and you lose, whether it's a criminal case, a divorce case, whatever it might be, if you don't like the outcome, you can go to the appellate court.
Right.
And then the appellate court has to give you an answer. So the 3rd District appellate court now would be cases coming out of those counties.
Out of those
Okay.
7
Now the
counties.
Supreme Court's a little different. Once a Supreme Court justice is elected, we hear cases from all over the state. So we don't really, we really just get elected from a district, but then we really are serving all the citizens of the state.
I see.
Okay.
I see.
So the appellate court then is the appeals court,
Correct.
and that is what you try, just the appeals.
That's right. I mean,
Okay.
just the appeals.
Okay.
So the appellate court, as Justice Burke said, has to take the cases.
Mhm.
And then if someone doesn't like what happens on the appellate court, then they have the opportunity to appeal to the Supreme Court, but that's not automatic. They
I
make
see.
a petition, and then the court reviews it. Justice Burke could talk better, but it's kind of I think the statistic is about 6% of those cases are accepted.
Okay.
So most end at the appellate court, but the really important cases, the court takes them and decides them for the whole state.
I see. And so can you talk a little bit about the process of taking on a Supreme Court case? If you were to, if someone were, obviously, as Justice just said, you have to petition the court
Right.
to be heard. Yes.
And we take usually between 5 and 8% of the cases.
Okay.
That's what it's been lately. And what we're looking for when, whether we take the case or not, is whether it's important to the judicial system, important to the citizens of the state. Every case is important to the litigants of that
Right.
case, and certainly not to diminish that importance. But we're looking at what's important for the whole system, basically. And one of the times when we will almost always take a case is if the appellate courts disagree on something. You have one appellate court, they'll say one thing on an issue, and then another appellate court, comes down differently on that issue. Then we would almost automatically take that case to resolve that conflict.
I see.
Very
So those
good.
are more than likely the hard cases or the heavy cases or
Right.
the extreme cases.
Which is, what I found, because I sat on the appellate court for 12 years,
Okay.
and now being on the Supreme Court, that is the difference. On the appellate court, there's a vast number of cases that are, I wouldn't say easy, but the outcome is fairly clear.
Okay.
As you're looking at the facts and the law. On the Supreme Court, it's a very gray. It's a lot of gray areas. So the cases are more difficult. And the other thing is, on the appellate court, you sit in panels of 3. On the Supreme Court, there are 7 of us, and all of us participate in every case.
Okay.
Okay.
All right. Very good.
Wonderful.
Perhaps the constitutional cases too.
Well, if there's a constitution, if from the trial court, if a trial court declares a statute unconstitutional, they don't go to the appellate court. They come directly to the Supreme Court.
To the Supreme Court.
And the chances of you hearing those cases.
That's automatic.
Okay.
That's automatic.
Okay.
That comes to us, and we have to hear it.
Okay. So then, who determines whether or not it's unconstitutional in order for it to even get to
The trial judge.
Okay.
On the appellate.
No, the trial judge on the
on
lower
on
level.
the circuit court.
Right,
Yeah.
and then it
I
bypasses
see.
the appellate court and goes to us.
I see.
I got it.
Well,
Okay.
there's a real hot topic that's happening in our midst that's going to roll out January 1, and that's the no cash bail, the Safety Act. Can you all speak to some of the ins and outs, the ups and downs, all of the arounds
Sure.
concerning that bill?
Sure. First of all, there are almost 60 lawsuits that have been filed already by state's attorneys in various counties asking to declare the statute unconstitutional.
Okay.
And those cases are being consolidated in Kankakee County. And so if the judge in the trial level in Kankakee County finds any part of the statute unconstitutional, then that would come up to us automatically.
Okay.
Okay.
So I can't speak to the merits of
Sure.
that, but we can talk about the statute as it exists now, because there is a statute that was passed by the legislature that is in existence, and the no cash bail part will take effect January 1st. And I will tell you that the minute it was passed, the Supreme Court, we got together and said we have to figure out how to implement this. And so we started a new agency called the Office of Statewide Pretrial Services. Right now, there are 90 people employed in that new agency. And
Okay.
we did a survey, and we found that 69 counties in Illinois had no pretrial services whatsoever. So
Mhm.
pretrial services is when someone's arrested, they go to bond court, and then the trial judge in bond court has to determine what the bail is.
Right.
Here, it's going to be basically either you're in or you're out situation. There is no bail that's going to be set after January 1st.
Wow.
So we have to get those judges sitting in trial court good information about the people who are appearing before them, have a risk assessment, and then if they are released on conditions of bail, well, it wouldn't be bail, the pretrial conditions, then they have to be supervised by someone, with our agency. So 69 counties didn't have any of that.
Wow.
Counties like Will and DuPage, they have, robust pretrial services already. We're going to go live in those 69 counties with our new system
Okay.
on January 1st.
Okay, so in order for me to understand you clearly, you're saying that come January 1, that there will be no bail, that either they will be retained or not retained?
Detained or not detained?
Detained.
Yes.
So who determines that? Would that be the trial
The
judge?
trial judge.
Within the confines of the new statute, there's
Okay,
a lot less discretion that the judges will have than they have now.
Okay.
So I think your viewers, I think people generally understand that it's worth maybe just pointing out for a minute what happens now.
okay,
So
Okay.
if someone's arrested for DUI
okay,
now, they're brought first to the station, and then they're brought ultimately in front of a judge. And the state attorney goes first. The state attorney says, Judge, Mary Jones has been charged with driving under the influence, and her criminal history is she has 3 priors. The last one was 2 years ago. She got conditional discharge, but she clearly didn't learn her lesson, Judge. And in this case, there was a fender bender, but it could have been more serious. And we're asking that you set bond in the amount of $30,000, 10%, so she'd have to post $3,000. The defense attorney, or public defenders appointed just for bond court typically, would then say, well, Judge, Mary Jones is married. She has 2 children. She works part-time. She supports them. She drives the kids to school. And she has car payments to make, mortgage to make. It would be very inconvenient if she was in. So she'll promise not to drink. You can make that a condition, but please don't set bond any higher than $5,000 because she can afford to post $550.
Okay.
The judge will then figure out what he or she thinks is the right thing to do, and Mary Jones either will post or will not post, depending. And there might be other conditions as well that the court would impose. Maybe a scram bracelet, for example. That's a bracelet that is put on people's ankle to detect alcohol through sweat.
Okay.
Things like that. So that's the current system.
Okay.
And judges oftentimes will set a bond much higher on more serious cases as a vehicle to keep people detained who they're worried about, either worried about a victim or worried about the community in general.
Right.
So that's the system as we have it today.
Okay.
There was a concern that has evolved nationally that the system is sometimes unfair to people with the exact same criminal histories. And let's say it's not a violent crime. Mary Jones, she can't post, $3,000.
Right.
She stays
Yes.
in.
Right.
Jim Jones, with the exact same criminal
Okay.
history, has the money in his back pocket and out he
post.
goes.
Mhm.
So, and you can come up with different scenarios
Sure.
to explain why that might or might not be fair.
Mhm.
So that, and I think the George Floyd incident, a number of other things, was kind of the genesis of we need to really reform this. But some who are opposed to it say they threw the baby out with the bathwater.
Yeah.
So we are the first state, I believe, in the country to
Okay.
completely eliminate cash bail.
Okay.
And that brings us to what Justice Burke was talking about in terms of what it's going to look like going forward. The elimination of cash bail, I've heard State's Attorney Berlin talk about this, other state's attorneys talk about it. It's not inherently a bad thing.
Okay.
But if you're going to do it, I think you need to come up with a system. I don't know what the system is, but you need to come up with a system where you actually can detain people who are a danger
Yes.
to the community
Mhm.
or to specific individuals. I think the fight and the consternation right now is, did the legislature strike the right balance?
Okay.
And obviously we won't express our opinions
Sure.
on that, but
Yeah.
there are serious questions that others are raising.
Okay.
Yes.
Right.
So with that being said, then that means that the discretion coming January 1, the discretion is taken away from the judges as to who can post bail or who would be detained and who would not be detained.
Right, because there are only certain offenses that a person can be detained,
Okay.
and those are very limited. And that's one of the challenges that the parties who are challenging this are making. It's a separation of powers issue. One of the challenges is that we're taking the discretion away from the judges on these other offenses that they
Okay.
could
Mhm.
otherwise
Mhm.
set a bond or a higher bond to
Sure.
detain them.
Yeah. And I mean, the purpose of having a judge is to be able to judge, not to have to judge the judge's judgment.
Right. Right.
That's true. I mean, it's true.
Yeah, and it's kind of like mixing it all up. I understand.
And so what I've seen is the controversy or the applause for the bill as opposed to the opposition to the bill kind of brings a divide between classes, because in the Black and brown community, they're saying, as the scenario that you stated, that this individual is not able to post bail, but this individual is able to post bail, so he should be released. And so, because she can't post bail, then it's looking like it's discriminatory against her because she can't post bail. And that's the narrative that has been put out in the Black and brown community that has caused such a divide. And it's really, what it's doing is it's causing a racial divide.
It
when
really
is. It has nothing to do with
race.
race.
Right.
That's correct.
Right.
And you know, it's obvious that bail and jail and prison policies must be reformed.
Right.
I mean, that's a given. I think everyone is in agreement with that. But I also think that, and tell me if I'm right or wrong, I think a part of the problem is that it seems I've heard that there has been some almost under the cover type things, almost as if people did not really know about this. And I don't mean people in our cities and in our states. I'm talking about legislators did not seem to have, I don't know if you can speak to that, but didn't really seem to have a clear understanding of all of this. And so at this point, this has been signed into legislation. So we don't, what happens?
Well, we
right
can
now?
speak to the history of it. And the history of it was that the bill was dropped on the senator's desks in the middle of the night on the very last day of the veto session. And then it was voted on. I think it was passed out of the Senate at 3 or 4 in the morning. And then it moved to the House. I think it was passed out of the House maybe around 10 in the morning. And they were swearing in a new legislature at noon. So they had to complete this. Otherwise, the whole process would start over again with the bill, with the new legislature. So that, again, is 760 some pages long. And it was presented to many of the legislators at the 11th hour.
I see. Yeah. Wasn't really no opportunity.
Yeah. For those of you that are watching us, we're interviewing with Justice Liam Brennan, who's running for Appellate Court District 3, and we're speaking with Justice Michael Burke, who's also running for Supreme Court District 3. And so if you have questions, we're dialoguing and talking about a lot of things that may not be clear to a lot of people. I know I'm being educated myself on a lot of what we're talking about. And but if you have questions, put them in the chat. If there's things that you want to expound on more as we're sitting here, feel free to do that. We're just so thankful to have you here and to bring clarity and enlightenment to all of these things that are happening, because we understand that where there's lawlessness, and this is what it's looking like it's going to generate, is a system of lawlessness where the judges, the power of the judges are taken away to a degree, and leaving it in the hands of individuals to determine, what they're going to do and what they're not going to do. There was an old saying that if you can't do the time, don't do the crime.
At least it used to be an old saying that said that. Yeah. I don't know how applicable that will be after all of this is over, but it also is quite apparent that this is going to affect law enforcement on a level that we've never seen. Can either one of you kind of speak to that, kind of give some insight into how this might adversely or even positively affect law enforcement?
Sure, I'll start, and then you can add something, Justice Brennan. But one of the main things that came out of this bill, was body cameras. That it mandates that every municipality and county sheriff has body cameras. And if you talk to police officers, they actually welcome that. Most of the police officers, I think all the ones I've spoken to, have. The only problem is it's an unfunded mandate, so you have a lot of municipalities that then have to go out and buy body cameras, and they don't have the money for them. The bill, as I said, it's 700 some pages long, and much of it has to do with law enforcement and law enforcement certification, discipline, things of that nature, training, and all those things are really good, but they should be thought through, with hearings and having input from law enforcement before it's passed. And I'm not commenting on what parts are good and what parts are bad, because I'm sure as with any anything. There are good things in there
Right.
and bad things.
Right.
One of the effects of this bill and just the general climate is that police departments are having a very difficult time recruiting.
Right.
And if we don't have good, honest, compassionate police officers out there protecting us, we're going to have a problem.
Yeah. Yeah.
Yeah, and bills like this, I'm sure, has the potential to make their job a whole lot harder, which does not help with recruitment.
Yeah. You know, I used to work for the city of Joliet as the personnel technician, and what I did is I would do the help with the recruiting for police and fire, do the agility testing, the psychological testing, and the written test and all of that. And we would have hundreds of candidates that would come in to apply for those positions, and then they would be put on an eligibility list and filled from that list as it came to it. But I don't think that that's what we're seeing in today. In fact, I'm hearing that a lot of police officers, they're walking away.
Right.
Well, anecdotally, we're seeing that a lot. In DuPage County, for example, there are no shortage of departments that are hiring gangbusters from the city of Chicago, which saves the suburban departments the training costs for the academy. But these kids are leaving the academy and going right to the suburbs, essentially.
Wow.
You know, there's aspects of the police that Justice Burke talked about. So after the George Floyd incident, obviously that raised, and everyone's had over a couple of other prominent cases too. You know, use of force. When is it appropriate? What should it look like? This act does actually, with specifics, address the utilization of force in certain circumstances, and also not only what kind of force can be imposed, but when it can be utilized. You know, for example, it's essentially instructing, as I understand it, officers not to pursue or to at least to use force to detain for minor offenses. Now, what is or is not a minor offense is in the eye of the beholder. But that's part of it. One other aspect of it is that to make a complaint about a police officer, historically, it couldn't be anonymous, and you'd have to, I don't know if it was an affidavit or certify or something like that what you were saying was true. They've removed those requirements, so you can make an anonymous complaint. And the problem that arises is, you know, we have clever criminals out there, right? I mean,
absolutely.
they'll be able to make, this officer's a pain in the neck to us on a regular basis. So in will come the complaint, and then the question arises: what is the sergeant or the chief of police or whoever it is? What are they supposed to do while they investigate? Is this person on desk duty? And I think the police are generally concerned about those aspects of it. Again, some of this stuff is good and necessary, and the reform, like you said, there's everything can be reformed.
Yes.
Except the judiciary. But those are aspects of it. And then the last thing I'll mention is that, and it's not in the bill, but it's a specter that's hanging over the next legislative session, is this question of qualified immunity. So police officers today enjoy what's called qualified immunity, which essentially makes it hard to sue a police officer unless their conduct meets a standard that I think we call willful and wanton misconduct. But it's a high standard.
Okay.
But there's been legislation that's, and I think it died when COVID hit, but the concern is that it's out there still, to remove qualified immunity. So you'd have police officers essentially needing to get insurance policies to protect them in their houses. So there's aspects of this that I think aren't finished yet, and we'll see where it goes.
See where it goes.
You know, when we look at what's happening in our nation, in our states, in our counties, the crime that is escalated at an all-time high, and then with this bill coming into play and coming into law, it just really leaves us to the place of how safe are we? You know, when you see these smash and grab things and you know, just all over, it really, what would be the reason for putting in this type of bill at this time when in our nation we're seeing so much crime taking place?
Escalated.
You know, there's a couple of things that I'd like to ask you all. Am I correct in hearing you say, and I believe I heard State's Attorney Glasgow say the same thing, that when you come before the judge for pre-trial, that you cannot look at their prior offenses?
No, you can look at their prior offenses. What you can't look at is their prior non-appearances in court to determine whether they're a flight risk.
Oh,
That's what he was referring to,
Okay.
I think.
and,
Okay.
and
But their prior offenses would not make them detainable if the statute otherwise allow them to be detained. So you could have somebody with a rap sheet deal, what we call it, a mile long, but if the offense they're charged with is not part of what the legislature said you can detain on, doesn't matter how bad it is,
Right.
they can't be detained.
so then what is the standard to determine whether a person would be detained? Is it just either I feel like today he should be, or I mean, if you can't look at history to make a judgment, what do you use to judge?
Well, again, that's one of the issues with the statute too. One part of the statute says you can look at whether they're a danger to the community, and then another part says you can look at whether they're a danger to a particular person in the community. So there's some inconsistencies that the legislature needs to clean up on this. But whether a person is a danger to the community can be looked at by the judge, and you can take into consideration, or the trial judge can take into consideration a person's prior criminal history as it relates to that.
It might be helpful to take just one step back looking at the statute. The statute starts by categorizing the defenses and putting them in baskets. And, first of all, it says if you commit a murder or an offense that's punishable by life imprisonment, there's actually, you can be detained. And the defense has the burden of showing why that person should not be detained. So, and similarly, by the way, sex offenses and some domestic violence offenses, they can be detained.
And this is under the
This
new
is under the new
legislation.
act.
Okay.
That's all good. There's nothing wrong with that.
Sure.
That makes sense. Then they look at felonies in general. They divide them into forcible felonies that are probationable and forcible felonies that are non-probationable. If you have a forcible felony where you have to go to the penitentiary if you're convicted, that is an offense, for the most part, that you have the option of detaining if certain findings are made. So, for example, aggravated arson, aggravated carjacking, aggravated kidnapping, that typically means either someone died or a gun was used, things like that. The judge will have the option. The state has to file a petition and show things, but the court will have an option in those cases to detain. But then anything that doesn't fit into that class of cases, and they're specifically spelled out in the statute, the way the statute's written, you can interpret it that the judge almost always has no power to detain. And that includes a lot of serious offenses, including normal carjacking, where you don't use a gun, but you push the lady down and you get into her car and you drive away.
You steal it.
Kidnapping without a gun. Arson. These are offenses that you may not detain unless you can show willful flight, which means I have a ticket to Buenos Aires in my pocket and I told my girlfriend I'm not coming to court. Or then it gets back to what Justice Burke said. Looking at the statute, there's inconsistencies. Some people say, oh no, if they're a danger to a specific person, you could detain. It's very smart people are looking at the statute and reaching different conclusions on that question.
Yes. Yeah.
Which is problematic.
Yeah.
Which
It's too
brings-
open-ended.
Yeah,
It's too
which brings
open-ended.
us to the point then of open-ended lawsuits. There could be lawsuits that come about because you detained, but the statute says that it was not detainable.
There will be many lawsuits filed by people who are detained, and the statute gives the state the option to appeal also. I mean, not so much lawsuits, but appeals
Sure.
from trial court rulings
Yeah.
on detaining people and then not detaining people.
Yeah.
So
But-
and sorting all this out is going to take quite a bit of time.
Yes, it is.
And
It
it's going to be
just
all
seems
in the
like,
Supreme Court.
yeah, it seems like a huge bowl of spaghetti and you're trying to find the end.
Yes.
Wow,
Yeah.
that is amazing.
I have one other question.
Mhm.
So I've heard the governor talk about being open to look at some review and to make some possible changes. Has any of that happened? And does it do any good before, January 1? I mean,
Well,
can
sure.
that even?
It will be very helpful if some of these changes are made to clean up what's in there
Okay.
before January 1. There is a group that's working. It's made up of legislators, police, state's attorney Berlin is on this group from DuPage County that's working through the statute to try and make changes to clean up some of it,
Okay.
basically.
Okay.
So, and that would be then presented during the veto session, which is between the election and January 1st.
Okay.
And so, with the lawsuits that have been filed, does that have any bearing on stopping any of this, or?
There's a potential for that if the judge in Kankakee County issues, either a temporary restraining order or preliminary injunction to stop this lawsuit. If the judge finds that there's some merit to these constitutional claims, that judge could say, "I'm going to grant, injunctive relief," which would then stop it until presumably, the appellate court looked at it or would come to the Supreme Court.
Wow.
It's quite a
We
bit.
have learned a lot today, gentlemen. We thank you so much for not only your time, but your wisdom. Thank you
Yes.
for being good justices, knowing what our law is and doing what, well, you swore you would do, uphold the law.
Yeah.
And we really, really appreciate that. Thank
It's
you.
been a pleasure being here,
Yeah.
Elizabeth. So thank you.
Thank you.
I can't believe it went so fast.
I know it does. Everybody
Usually
says
does.
that.
Yeah.
Everybody says it goes
Yeah.
really fast. Yeah.
Yeah. We really appreciate the fact that you are making the sacrifice, because it's a great sacrifice. You're sacrificing your time, your family, your money in order to run in these races, all for the express purpose of upholding the law
Yeah.
and doing what's right. And we don't find a whole lot of that. And so I
It's
really commend you all in your ethics and your integrity and being able to hold up the law. I just met you guys during the race that I'm running in, and as we were talking about at the beginning of the show, just being able to meet some wonderful people and
Yes.
just really hone in on the integrity. Just knowing the spirit of a person.
Yeah.
It exudes from you guys.
It
and,
really does.
I really appreciate that.
And we are going to keep both of you all in our prayers
Yes.
as
Thank
you
you.
go through your campaigns and ultimately going into those offices and seats that you're going
Yeah.
after. Well,
And
it's
we
been
want
great.
you to win too.
Yes. Yes.
Absolutely. Absolutely. So
Yeah, we do.
again, those of you who are watching, I'm Dr. Glenda Wright McCullum, running for Will County Board District 7. So those of you that are in my district, I solicit and I would respectfully ask for your vote. And I'm sure that Justice Burke and Justice Brennan are in your district to run. You have Will County.
All of Will County.
All of Will County.
So they
So
will
come
be
on.
your ballot.
Yes.
Those of you that are watching. So let's get them in these seats. It is critical
It's
and
critical.
imperative that we get good representation and those who will follow the law into these seats of authority.
Well, we have so enjoyed hanging out with you guys as always.
Yes.
And we will see you next week. But until then, I'm Apostle Nona Ray.
I'm Apostle Glenda Way, and
And-
let me just say this. And I said Apostle Glenda Way.
That's all right.
Let me say this. Tomorrow, our broadcast, we're doing a special edition with Cindy Bailey, who is the wife of Senator Darren Bailey, who's also running for governor. And so tune in tomorrow at 5:30. We're doing a special broadcast with her. We had a wonderful time.
Great time.
with,
She's a
Cindy
great,
Bailey.
great
Just-
lady.
Just people that are just really down to earth. And
Mhm.
so, having said that, I'm Apostle Glenda Wright.
And we are
God's
God's girls,
girls,
keeping it real. See you next week.
Have a great evening.
am Apostle Nona Ray.
And I'm Apostle Glenda Ray.
And we are God's girls, keeping it real.